Good afternoon, ladies and gentlemen, and honorable panel members. My name is Reshad Imam. Today I'm going to talk about the enforcement of contracts in the writ jurisdiction. Now, before I get into the legal aspects in this regard, I would first like to provide a little context as to why this area of law is so important as far as Bangladesh is concerned. We know that the government is the largest employer of contractors for execution of public works through contracts executed between the parties. Now, during implementation of these contracts, disputes are bound to occur, and the same are to be resolved either through ADR, which is alternative dispute mechanisms, for example, arbitrations in a contract, or through a suit under the Civil Procedure Code or the Specific Relief Act. Now, a suit under the Civil Procedure Code, we all know, can be extremely lengthy, tedious, and very, very expensive. And arbitration is no different, as has been very well discussed in the last session. It is intended to be a speedy remedy, but hardly ever is. I can give you one example which my learned senior Mr. Akhtar Imam gave as well. An arbitration award, a favorable arbitration award, was obtained by a client of Akhtar Imam and Associates in the 1980s. The matter is still pending in court. Now, let me pause there for a moment and let that fact sink in. 30 years, the matter is still pending in court. Such delays are a cause for significant concern. Whether the contractor has a speedy relief in such a situation, or is he destined to suffer the slings and arrows of outrageous fortune at the hands of unjust, arbitrary actions of public authorities. Now, with this context in mind, let me move on to my very first slide. I've broken down the topic of discussion today into various parts. As you can see, the first one is, what is a writ? This is the very generic question which I will address. Then we have the provisions of the Constitution which specifically deals with writ jurisdiction. Then I will discuss the various types of contracts enforcing which the writ jurisdiction can be invoked. Then I will give a brief summary of the legal position. And then I will talk about a very important report which was discussed in the very first session today, Ease of Doing Business Ranking, prepared by the World Bank. Then I will talk about a very exciting new case of Abdul Hakim. And then, of course, I will conclude with the 11th segment. Now, with this structure in mind, ladies and gentlemen, let me start with the very first slide. There we go. What is a writ? As you can see on the slide, ladies and gentlemen, a writ is essentially a formal written order issued by a body with administrative or judicial jurisdiction. Now, it is essentially a written document by which one is summoned to court to either do something or refrain from doing something. Now, the power of writ jurisdiction is provided in Article 102 of the Constitution. This provides power to the High Court Division to issue writ against a person or authority, as you can see on the second bullet point, ladies and gentlemen, against a person or authority performing function in connection with the affairs of the Republic or of a local authority. Now, for the sake of this presentation, I would just like to refer to them as public bodies. Article 102.1, ladies and gentlemen, is in relation to the infringement of fundamental rights which have been provided in Part 3 of the Constitution. And Article 102.2 deals with the violation of rights other than fundamental rights. We can call them non-fundamental rights, if you please. Now, there is a very important distinction between Article 102.1, as you can see, and Article 102.2. If you file a petition under Article 102.1, you do not need to establish that you have exhausted all alternative remedies. However, if you file a petition under Article 102.2, you must establish that you have exhausted all alternative remedies. Now, we have to keep this distinction in mind and proceed further into this presentation. As you can see, the last bullet point, there are 5 different types of writs that can be issued by the Honorable High Court. The first one is Mandamus. This is a Latin term which essentially means we command. This is ordered by the court to direct a public body to do something. Then we have certiorari, which essentially means be certified. This is issued to declare any act done by a public body to be illegal. Then you have prohibition. This is issued to prevent someone from doing something. Then you have habeas corpus. This is also a Latin term which essentially means have his body. This is issued to bring someone held in custody to court. And then you have the last one, which is quo warranto. This essentially means by what warrant or authority. This is issued to remove illegal occupation of public office. Now that we all know what a writ is, we can move to the very next slide, which is, can contractual rights be enforced under Article 102(1)? The answer, yes, if there is a breach of a fundamental right guaranteed under the Constitution. And we have to remember that when it comes to mala fide acts, arbitrary acts of public authorities, the court in several cases has held that these constitute violation of fundamental rights. So a mala fide act or an arbitrary act by a public body will always be deemed to violate fundamental rights of the petitioner under Article 27, which is the fundamental right to equality before the law. Now, ladies and gentlemen, with this, I will move to an example of a petition which was filed in this regard. If an employment contract with a public body includes a clause which prevents the employee from practicing his or her religion, for example, ban on hijab at the workplace, which is a very relevant topic in the West nowadays, especially with Trump in power, the employee might file a petition under Article 102(1) seeking enforcement of Article 41 rather, of the Constitution, which is the freedom of religion. I repeat, the employee may file a writ petition under Article 102(1) for infringement of Article 41 of the Constitution, which is freedom of religion. Now from this topic, we move to the next one. Can contractual rights be enforced under Article 102(2)? Ordinarily, no. You cannot enforce a contract under Article 102(2), since the reason being simple. As you would remember, there is an alternative remedy available in the form of a suit under the Civil Procedure Code and Specific Relief Act. However, luckily for everyone, there are exceptions to this. As you can see, employment contracts with local authorities, statutory contracts, violation of statutory provisions, pure and simple trading contracts with international obligations. Now, I want to address each of these exceptions individually. Moving on. Employment contracts. As you can see, in relation to service contracts with the Republic, alternative remedy provided in Article 117 of the Constitution gives exclusive jurisdiction to administrative tribunals, which has been set up for this purpose. So there is an alternative remedy, so you cannot invoke the writ jurisdiction. However, there is only one exception. If, once again, there is an infringement of fundamental rights guaranteed under the Constitution. Let's take an example. A non-compete clause in a service contract with the Republic may be deemed to violate Article 40 of the Constitution, which is the freedom of profession or occupation. Coming to the second bullet point, ladies and gentlemen, service contracts with local authorities. Now, alternative remedy available under CPC or the ADR. We all know that there is an alternative remedy available, but there are exceptions to this, and those exceptions have been provided by the landmark case, as you can see, of BSIC versus Mahbub Hussain. The court stated that if there is a contravention of a mandatory statutory provision and or violation of the principles of natural justice and or substantial disregard of the terms and conditions of service prescribed by legislation, writ jurisdiction can be invoked. Now, moving on, ladies and gentlemen, to statutory contracts. Now, writ is only available in relation to Article 102 when the court deems a contract to be a statutory contract. Now, in what situation will the court deem a contract to be a statutory contract? Let's look at the landmark case of Sharping versus Bangladesh. This is from the 1980s, and it is still very highly regarded, ladies and gentlemen. The court in that case provided guidelines. Court stated that pure and simple trading contracts, writ is not available for breach of those contracts. As simple as that. If it's a pure and simple trading contract, you cannot invoke the writ jurisdiction. However, if the contract is where the public body acts as a sovereign, this is the key part. This is the concept that was introduced by this case. If the public body is deemed to act as a sovereign and discharges sovereign functions, the court, as you can see, will deem the contract to be rooted in statute. These are the exact terms, quote unquote. Court will deem it to be rooted in statute. And in that case, writ jurisdiction is available for breach of that contract. Moving on to a landmark Indian case of India Thermal Power, you can see that it laid down a specific condition that if there are prescribed terms and conditions and it's a must under the statute, then the contract becomes a statutory contract and writ is available for breach of such contract. Now, combining these two principles, one, the concept of sovereign introduced by the Sharping case, and India Thermal, we come to our next slide, which is the landmark case of Power Development Board and Asaduzzaman Shikdar. The court provided several guidelines, and I have just noted down the relevant ones. Writ is available when public body exercises statutory power to enter into the contract. Writ is available when government enters into the contract in capacity as a sovereign. This is the Sharping bit which have been adopted. Writ is available if entering into the contract containing prescribed terms and conditions is a must under the statute, then that contract becomes a statutory contract. This, you would remember, has been adopted from the Indian case of Thermal. And last but surely not the least, if a contract incorporates certain terms and conditions in it which are statutory, then the said contract to that extent is statutory. Now, ladies and gentlemen, as you can see, the case of Asaduzzaman Shikdar builds on the decision of the Sharping case and widens the scope of the writ jurisdiction to, in my humble opinion, to a great extent. And it will only prove to be helpful. Then you have, I will not go into too much details about this section, violation of statutory provision of available when there is a breach of a statutory provision made by a public body in a contract regulated by statute. There is no doubt about that. We have next one. This is the very interesting slide, ladies and gentlemen. Pure and simple contracts. Now, ordinarily, as I have stated before, when it comes to pure and simple contracts, writ jurisdiction is not available. Why? The reason, once again, is simple. There is an alternative remedy available under the Civil Procedure Code and the Specific Relief Act. However, an exception has been made out in this landmark case. As you can see on the slide, BIWTC versus Birds Agencies. In this case, the court stated that if there is an international obligation, once again I'm repeating, if there is an international obligation attached to the contract, then it becomes a matter between the state and another state, and it goes beyond the scope of an ordinary and pure and simple contract. I will repeat, if there is an international obligation attached to the contract, then it becomes a matter between the state and another state, and it goes beyond the scope of a pure and simple contract. But the most interesting thing that comes out of this case, in my at least humble opinion, is the principle of fairness became consideration. The court applied an equitable principle to widen the jurisdiction under Article 102(2). Now, building on that, the very next case, Vasa versus Superior Builders, goes on to extend the jurisdiction even further. As you can see on the slide, the first bullet point, the doctrine of legitimate expectation is an extension of the doctrine of fairness. I mean, you can argue that if the principle of fairness and the legitimate expectation, principle of legitimate expectation and even reasonableness is used to widen the scope of the writ jurisdiction, there is a danger of opening the floodgates. However, this will surely widen the jurisdiction of the court and provide a speedy remedy for contractual disputes against public bodies. Now, just to recap, ladies and gentlemen, writ is available for enforcement of contracts between an aggrieved person and a private and a public body under both Article 102(1) and Article 102(2). Under Article 102(1), you have the infringement of fundamental rights. You have to show infringement of fundamental rights. There is no need to satisfy the court about exhaustion of alternative remedies, and malafide, arbitrary and discriminatory acts will infringe fundamental rights. Example, a non-compete clause will always infringe Article 40 of the Constitution. Under Article 102(2), you have employment contracts with local authorities as per guidelines provided by BSIC versus Mahbub Hussain. You have statutory contracts as per guidelines provided by the Sharping case and Asaduzzaman Shikdar case. Then you have violation of statutory provision in a contract regulated by statute. And then you have the pure and simple trading contracts as per BIWTC versus Bird's agencies, which introduced the concept, the equitable principles, to be a determining factor for widening the scope of the writ jurisdiction. That is the principle of fairness, the principles of legitimate expectation. Now from the legal aspects, let's move on to something which we are all interested in, which is the ease of doing business ranking prepared by World Bank. Now, enforcing a contract remains a key challenge in improving business climate in Bangladesh. In the Ease of Doing Business Report 2018 prepared by World Bank, every year actually, quality and efficiency in the court system of every country is scored by using data. There is a specific indicator. I will repeat, there is a specific indicator in the report called Enforcement of Contract Indicator. Enforcement of Contract Indicator. There's a specific segment in the report. According to that report, it takes 1,442 days to resolve a contractual dispute through a local first instance court in Bangladesh. I repeat, 1,442 days, which means over 4 years. Over 4 years, ladies and gentlemen, to resolve a contractual dispute in a local first instance court of Bangladesh. Let's compare that to the United Kingdom. Reports suggest that it takes 437 days in the United Kingdom to resolve a similar dispute. And it takes even less, 164 days in Singapore. The difference, ladies and gentlemen, is staggering to say the least. The total score, as you can see, for Bangladesh in relation to enforcement of contract indicator prepared by World Bank is 22.1 out of 100. 22.1 out of 100. And let's look at the ranking of Bangladesh in relation to enforcement of contracts. We are 189 out of 190 countries. Well, at least we are not the worst, if that's any consolation. As such, ladies and gentlemen, there is an urgent and desperate need to take positive steps to improve this score and the ranking. One must bear in mind that this is only talking about the local first instance court. After that, there may be several appeals, and the judgment eventually to be delivered by the appellate division may take up to 20 to 25 years. I mean, I'm not blaming anyone, but this is mainly due to a log of cases in every court of the country, and the use, of course, of dilatory tactics by the parties. As such, the harsh reality, ladies and gentlemen, is a middle-aged person like me, if I decide to file a suit under CPC, I might not live long enough to see the resolution of the dispute. That's the harsh reality. I might not live long enough to see the resolution of that dispute. Now, ladies and gentlemen, moving to something more optimistic, we have the case of Abdul Hakim. The judgment was delivered by our very own Dr. Justice Syed Rifat Ahmed, sir. The court in this case stated that, this is very interesting, and I would ask the young members of the bar to carefully look at this. The court stated that in certain sectors, such as education and health, activities of private bodies are essentially functions belonging to the public domain. Once again, I'll repeat, you have not heard me wrong. Activities of private bodies are essentially functions belonging to the public domain. As such, writ jurisdiction may be invoked against such private bodies. The Abdul Hakim decision of the High Court Division, in my opinion, is a remarkable instance of judicial activism in the field of administrative law. Although the case of Abdul Hakim is pending in the Appellate Division, the High Court judgment gives us tremendous hope for the future of this jurisdiction. Now, ladies and gentlemen, coming to my last slide, it is essential that at least contractual disputes against public bodies are resolved in the shortest possible time frame in order to provide a cost-effective and expeditious form of relief to litigants, as otherwise it will directly affect a person's access to justice. Writ petitions may take up to 360 days, that is up to a year, to be disposed of. As such, it provides a speedy resolution of contractual disputes with public bodies. One may hope and pray that the writ jurisdiction under Article 102(2) shall evolve with changing circumstances by following the remarkable trend that has been set by cases like Sharping, Birds, and more recently Abdul Hakim. The courts can use various equitable principles to do this. Courts can use the principles of legitimate expectation, they can use the principles of fairness, and even the Wednesbury reasonableness, which is a very well applied doctrine in the UK. I mean, it is essential for the court to apply these equitable principles to widen the scope of the jurisdiction in order to provide an effective relief to litigants who are filing enforcement of contract claims against public bodies. There is also, ladies and gentlemen, a very desperate need. As you can see, the third bullet point on my slide, there's an urgent need to simplify the legal position in this regard. This is in order for private contractors to fully understand their rights in relation to application of the writ jurisdiction in enforcing contracts against public bodies. These steps, ladies and gentlemen, will not be a miracle cure, by the way. One might hope it would be, but it would never be a miracle cure. But these shall surely have a positive impact on the total score and ranking which have been given to Bangladesh by the World Bank in its Ease of Doing Business report. We must all remember that when a legal redress is available, but is not forthcoming in a timely fashion, it is the same as having no redress at all. After all, justice delayed is justice denied. Thank you, ladies and gentlemen, for your time. Thank you, honorable panel members, for your patience. And last but surely not the least, thank you, Barrister Anita Ghazi Rahman, for giving all of us this intellectually enriching platform called Think Legal. Thank you.